Hello, everyone. Sorry for the slight delay. We had a little bit of a technical difficulty, but we're all set now. And thank you so much for being here. My name is Kristan McMahon, and I serve as the president of the Robert H. Jackson Center in Jamestown, New York. We have long recorded everything we do, and I encourage you to check out our YouTube channel. But thank you so much for joining us for our inaugural live stream program. I have been the president of the Jackson Center for just under a year now. And although I have a background in law, there is much about Justice Jackson, his writings, his speeches, and his work that I'm still learning about. These live stream programs will be a combination of discussions with me about what I'm learning, and then others focused on those who are experts in their fields and who are addressing today's challenges with a Jacksonian outlook. We look forward to sharing these with you. This year is one of Justice Jackson's milestone years. On May 2nd, 1945, he was appointed the Chief of Counsel for the United States to bring the suspected Nazi war criminals to trial. This first Tea with RHJC program has its genesis in a talk I was supposed to give last week on the London Agreement and Charter. The London Agreement and Charter was signed by the United States, the Soviet Union, Great Britain, and France on August 8th, 1945. I'm going to acknowledge at the top that I am not a subject matter expert on anything I will be talking about today. And this talk is definitely geared towards giving a layperson's understanding of the London Agreement and Charter. There will be time for your questions at the end. And while I may not be able to answer all of your questions off the top of my head, I promise you I will do the research and get back to you at our next tea. So let me start you through my process. The first thing I did was some light research for context. I wanted to try and understand at least a high level the experiences that shaped the thinking of those in the deliberation room. So let's start with the stark numbers. The first, and these are going to be the death and injury numbers. So France had approximately 210,000 military deaths, approximately 390,000 civilian deaths due to military activity or crimes against humanity, and then approximately another 390,000 military who were wounded. In the United Kingdom, the military deaths were 383,000. The civilian deaths due to military activity or crimes against humanity were a little over 67,000, and the military wounded were a little over 376,000. In the Soviet Union, the numbers are an order of magnitude higher. The military deaths ranged from 8.5 million to 11.5 million. The civilian deaths due to military activity and crimes against humanity were between 4.5 million and 10 million, and the military wounded was nearly 15 million. And in the United States, in both the Atlantic and Pacific theaters, the military deaths were a little over 407,000. The civilian deaths due to military activity were about 12,000, and the military wounded were about 671,000. Now, I will admit that I pulled these numbers from Wikipedia, from a particular article, because it broke it down in the way I wanted to see it. I was really looking to get an understanding of both the military and the civilian impact of the war. However, I did check these numbers against a couple of other sources and to get a handle on overall accuracy, and they are in line. So that's the human toll. What about the damage to the countries themselves? So of France's 38,000 or so municipalities, a little shy of about 5% of them were declared war damaged. And that has a very specific designation. It means that damage or destruction occurred in at least 30% of the buildings in each of those towns. While that seems like a fairly small percentage, it does include 20 of France's largest 27 cities. So approximately 18% of all of the buildings in France were listed as destroyed or seriously damaged. And one thing I'd not fully internalized prior to doing this research is the vast majority of that destruction was actually done by the Allied powers while they were trying to curtail Nazi advancement or expel the Nazis from France. For the United Kingdom, I struggled a little bit to find a source that laid out the damage estimate for the United Kingdom as neatly as France did. Everything I found seemed to focus on the damage to London during the Blitz. So according to National Geographic, about 70,000 of the buildings in London were completely demolished, and another 1.7 million were damaged. That amounted to approximately 75% of London being demolished or damaged during that 8-month period. And in addition to the bombs being dropped in London, the Germans certainly did not limit themselves just to London. So they also raided Belfast, Bristol, Coventry, Hull, Newcastle. The list is not quite endless, but certainly extensive. And you can just imagine the mindset of the British. And in the Soviet Union, during the Nazi occupation, approximately 1,700 cities and 70,000 villages were totally or partially ruined and or burned. This resulted in the destruction of approximately 6 million buildings, 32,000 businesses, and left almost 25 million people homeless. All right, so that gets us through the physical damage. And that helps us understand the lens that the negotiators came into the post-war decision-making and determination on how to punish the alleged Nazi war criminals. Now, this certainly wasn't the only thing that colored their lens. And this wouldn't be a Jackson Center talk if it didn't touch on the law at least a little bit. So let's turn and take a look at the legal systems. Because in order to be able to move forward, they needed to have an understanding of if there even should be a trial. And if they did decide to have a trial, what would that look like? So the impetus for the International Tribunal came from the United States. It certainly wasn't a unanimous or united thought amongst President Roosevelt and his cabinet and advisors. In fact, if you had asked him that question earlier in the 40s, a trial likely would not have been what the United States suggested. But by early 1945, President Roosevelt had been convinced that a real trial was what was necessary for the alleged Nazi war criminals. And so in February 1945, he took a plan. It was one that his secretaries of war and state and his attorney general had championed. And he took that with him to Yalta when he met with Winston Churchill and Joseph Stalin. Now, this wasn't the first time that a trial was going to be discussed and brought up. In November of 1942, the Soviet foreign minister had suggested setting up a foreign tribunal for the major war criminals. And honestly, this took the British by surprise. Britain's officials, for the vast majority of the war, were adamant that a trial was undesirable. It was too slow, it was too much process, and it would be way too hard to administer. In fact, by February of 1944, there was a brief circulating in the British Foreign Office called Against the Establishment of an International Court. And they had thought by that point, nearly 2 years later, 18 months later, that they had gotten the Soviets on board with their plan that a trial was not necessary. The British had also assumed that the Americans would feel that same way. In subsequent conversations with the Russian government officials and with Stalin, by late 1944, it was quite clear that Stalin still firmly believed that the leading Nazis should have a trial before they were put to death. He didn't feel the same way if the likely result were going to be life imprisonment. He wanted that trial to sort of confirm the decision to put these alleged war criminals to death. So when the parties met at Yalta and Roosevelt made his proposal, the British at that point were the only ones who stood on the side of not having a trial for the major war criminals. Now, as they always say, the devil is in the details. A small delegation of Americans arrived in London in early April of 1945. They brought with them an outline of the composition of the tribunal, the nature of the charges, the difficulties of dealing with the crimes against German nationals, and the criminal liability of the superiors who had given the orders but not committed the crimes themselves. the Americans were empowered to sign an agreement as soon as one could be arranged. The British, however, were not anywhere near willing to move with that depth, breadth, or alacrity. In fact, Churchill and his cabinet had announced on April 12th of 1945 that for the principal Nazi leaders, a full trial under judicial procedure was out of the question. Now, on that same day, April 12th, President Roosevelt died. This resulted, obviously, in the transition of power to President Truman, and President Truman also wanted a trial. He had great respect for the power of law to do good and in the wisdom of judges. And so President Truman wanted to get to an agreement on the details as soon as possible. The Americans in Europe also continued to bolster their support. They went to France and spoke with Charles de Gaulle. He was also in favor of a trial. And the British held out on the trial part until the end of May. But by that point, the United States had its wheels in motion. President Truman had appointed Robert H. Jackson as the chief U.S. counsel at the end of April, and that appointment was officially announced on May 2nd. Germany surrendered on May 7th, and so things started moving quite rapidly. The Supreme Court wrapped up its term on June 18th, although Justice Jackson ended up departing before all of the opinions on that day were read. They had gotten off their process a little bit by interrupting their session to head over to the chamber at the House to hear General Eisenhower speak. Jackson had been in London a couple weeks before, in earlier June as well, in an effort to try and secure the British agreement to his plan. He was very frustrated with how slowly things were moving. At that point in early June, the French had not yet decided on their delegation. The Russians were not fully committed to a trial. Justice Jackson, thought it preferable to move forward with all of the allies towards a trial, but he was also fully prepared to go it alone if that was necessary. He could not conceive of a way or the good way to punish the alleged criminals without a trial, and he also could not conceive of a system that would free them without one. So the French delegation arrived on June 24th, the Russians followed a day later, and the London Conference officially kicked off on June 26, 1945, just about 8 weeks after Germany's surrender. And Justice Jackson initially thought that getting to an agreement would be a fairly short process. He thought he had done the necessary groundwork with the British. He thought just the mere presence of the others at the negotiating table meant that they were in favor of the plan. So the four allies agreed that a military tribunal would, rather than a civil one, would enable them to tap into the best elements of their legal systems. The first hurdle was that the four allied countries had differing legal systems. So the American and British operated under the common law system, and the French and Russians practiced under the continental or civil law system. At a high level, the primary difference is that in the common law system, case law is what is of primary importance, and in the continental system, it is codified statutes. So there are some differences in what attorneys are responsible for, and also some differences in the flexibility and discretion that judges have with regard to their remedies and their powers to directly examine witnesses and defendants. The second hurdle was challenging assumptions. So, as I had mentioned, Jackson had assumed that everyone's presence at the table meant that they were in favor of proceeding with a trial, and not to any small credit to him, also with his plan for how that trial should unfold. He learned very quickly, in fact, during the second session, that this was not the case. When a member of the Russian delegation announced that the tribunal's job was simply to announce the just punishment for the offenses which had been committed. He had said in Russia they had announced that all of the Nazi war criminals were guilty, and so this tribunal's job was really to ratify that. A third hurdle was how to handle the organizations and institutions in the Nazi regime, not just the individuals. Everyone agreed that the Nazi organizations were also criminal groups, but the French and Russians were quite skeptical about the court's ability to pronounce a judgment against them. And they worried about how to handle the guilt by association factor. They had some concerns that thousands of people would be coming out of the woodwork. And under Soviet law, especially, no one but a physical person could be tried for a crime. Justice Jackson tried to instill the American principle under which corporations are also seen as persons, but the Russians couldn't quite see how to make that work. And the final hurdle, major hurdle, was the aggressive war charge. So Jackson saw this war of aggression as the cornerstone of the case against the Nazis, and that everything else actually flowed from that. He really wanted to try and make the case that any and all war was a criminal act. While the other delegates agreed that the aggressive war was certainly a morally correct charge, they thought the Americans were trying to invent a crime that didn't exist. The criminality of aggression itself had never been addressed anywhere at that point. And the Russians and French wanted to focus on the specific acts of breaking the treaties and the invasions themselves. So, unlike the short process that Justice Jackson had thought, the negotiation continued for weeks. The Russian delegation held out until after the Potsdam Conference in mid-July of 1945, so we're already not quite a month in to the negotiations. During the Potsdam Conference, the British and the Americans were very enthusiastic about the need for a trial. And that convinced Stalin that the work of the group in London should be approved as soon as possible. So the negotiations largely wrapped up by August 2nd. Although Jackson had the power to sign immediately, power needed to be granted to the members of the other three allies. And so the agreement and charter were finally signed on August 8th, 1945, a full 6 weeks after the start of the London Conference. So as an aside, if I had time, I would have also delved into the individual negotiators at the conference and their backgrounds a little more than I was able to. I would have liked to have understood what their potential biases and slants might have been coming into this. The national suspicions, if anybody had a chip on their shoulder, had there been behind the scenes instructions from the home offices to try and delay. I like getting down into that nitty gritty, but at a certain point, you have to stop researching and start writing or start talking. So let's turn to the agreement itself, which is pretty short. The agreement itself is a pithy preamble and 7 fairly succinct and easily understandable articles, especially when you consider the number of lawyers who were involved in its drafting. It established the tribunal. It incorporated the charter, and the charter described the makeup, the jurisdiction, and the function of the tribunal. And the agreement also required that each of the allies make any alleged war criminals they were holding available for trial. This was not an insignificant article because each of them were holding some of the criminals. It also enabled the other countries to sign on to the charter. And eventually 19 other countries signed on to the charter, 9 of them in Europe and the other 10 around the world. The charter is about 4 times as long with 30 articles, and its job was to attempt to blend the 2 legal systems. So this proved to be pretty easy with regard to the process and procedure side of things. And to Justice Jackson's way of thinking, it provided more procedural rights for the defendants than either of the systems would have provided on their own. So all 4 of the allies had agreed that the accused had the right to counsel, and they had the right to an indictment and a trial in their own language. The indictment would include a full summary of the charges and as many of the relevant documents as possible, and that was from the Continental system. The defendants would have the right to testify under oath and be cross-examined, and that was a common law principle. And the defendants would also have the right to make a final statement without a challenge from the prosecution and not under oath, which was also a continental. Rather than discuss all of the articles, I'm going to focus on Articles 6 through 10, which are the definition of the crimes and those who can be charged with them. Justice Jackson had hoped that these crimes, all of these crimes, would not be limited to just the access powers. He believed that these were universal crimes, but it is quite clear in the opening paragraph to Article 6 that these were limited just to the access powers. These crimes were also vague enough that it left some latitude for the tribunal judges during the trial itself. So the first is the crime against peace, namely the planning, preparation, initiation, or waging of a war of aggression or a war in violation of international treaties, agreements, or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. So this circles back to the fourth hurdle that we discussed. The introduction to this article makes it clear, as I said, that it was contemplated to only punish the European access powers. This definition also limited the ability to prosecute someone to those charges related to the waging of a war or a war in violation of an international agreement. So by limiting it in this way, it would have limited the prosecution's ability to incorporate something like the Nazi invasion of Czechoslovakia or the Anschluss, because no fighting took place in either of those. It did, however, incorporate the concept of conspiracy. And Justice Jackson had originally thought that conspiracy should be its own crime. But that wasn't readily acceptable by the French or the Russians. So it is incorporated here, and it is also incorporated in the paragraph at the end of the definitions of the crimes in Article 6. The second is war crimes, namely the violations of the laws or customs of war. And these violations would include such things as murder, ill treatment, deportation to slave labor, or for any other purpose of a civilian population of or in an occupied territory, the murder or ill treatment of prisoners of war or persons on the sea, the killing of hostages, plunder of public or private property, wanton destruction of cities, towns, and villages, or devastation not justified by military necessity. So this was actually a fairly typical litany of the crimes related to war, and it would have been very familiar to everyone. It becomes a little more radical for the era when it's combined with Article 7, which we'll get to in a moment. So the third and final crime is the crime against humanity, namely the murder, extermination, enslavement, deportation, or other inhumane acts committed against civilian population before or during the war, or persecutions on political, racial, or religious grounds in execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of the domestic law of the country where it was perpetrated. Had to read that one. So this was a brand new crime, and one designed to express the complete abhorrence for the Nazi beliefs, methods, as well as the scale of the atrocities. This also must have been a tricky needle to thread because of the issue of national sovereignty. So the negotiators were mindful of the need to avoid interference in another country's domestic policy. So they seemed to limit it to the acts committed during the war itself. However, it injects a moral component by enabling prosecution for these crimes, even though the law of the country did not hold this behavior to be criminal. So the concept of the rule of law can be a slippery one. The phrase essentially means that the behavior comports with the law. So to my way of thinking, that means subjective ideals like humane or moral or good have no place in the definition, even though I do think that's generally what people mean when they talk about the rule of law. So when the laws are changed, such as they were in Nazi Germany, the inhumane behavior technically fell under the rule of law as it had been adapted. I confess this amorphousness of the rule of law definition challenges me on the regular. Trying to develop programs for the center, focused on the rule of law has become, at least for me, a lot more fraught. So now that we have the crimes defined, let's look at Articles 7 and 8 to understand who could be charged with them. Article 7, and I'm paraphrasing here, heads of state and other responsible officials were not immune to prosecution. And in Article 8, the fact that someone was obeying an order from the government or a superior would also not provide immunity against prosecution, although it might mitigate the punishment. So this enabled everyone involved to be prosecuted potentially and allowed no one to hide behind the technicalities. Justice Jackson had said, if the leaders could not be prosecuted merely for giving the orders, and the ones who perpetrated the acts could not be prosecuted simply because they were simply following orders, then essentially no one could ever be prosecuted for these crimes. And that was not how the system was meant to go. And then finally in Articles 9 and 10. Article 9 allowed the tribunal to declare any group or organization a criminal one during the trial of one of the members of that group, because it connected the activity of that individual to the group at large. And then also the converse to that, Article 10 enabled the signatories to bring to trial the other members of the group that had been declared criminal. And because that group had already been declared to be criminal, that could not be questioned in court subsequently. So they were able to reach, at this point now, the people who had given the orders, the people who carried out the orders, the people associated with the organizations under which those orders may have been given or the atrocities may have been committed, and then the organizations or groups themselves. So it was ended up being the broadest possible scope of who could be prosecuted. So now, why is this important? And why did you tune in today? Now, I enjoy history for history's sake, but I also think we could use it more to inform what we're doing today. So first and foremost, as we're fond of saying at the Jackson Center, the London Agreement started us down the road to Nuremberg. From here, Justice Jackson and his trial team and the trial teams from the other allies moved in earnest to develop the cases against the first 22 defendants. And that first Nuremberg trial was the first of many. And so over the subsequent 3 to 4 years, multiple trials unfolded using these crimes as their base. Subsequently, in the years following the Nuremberg trial, the American Declaration of the Rights and Duties of Man and the United Nations Universal Declaration of Human Rights were adopted, and the United Nations Convention on the Prevention of the Crime of Genocide and 2 of the 4 Geneva Conventions were created. And these all have their growth out of the definition of these crimes and how to stop them from happening again. The agreement and the charter also created the first International Criminal Court. Almost 50 years passed between the first Nuremberg trial sentence and the next International War Crimes trial, which was the International Criminal Tribunal for Yugoslavia. In 2002, the permanent International Criminal Court was established by the Rome Statute. So the court itself also became finally a permanent body. And for more than a decade now, the international prosecutors have gathered each year for an open discussion on the challenges facing international criminal prosecution. This typically happens at the Chautauqua Institution after the season, but it has also happened in Nuremberg, and it will be in London next year to commemorate the signing of the London Agreement and Charter. We meant to go this August for the 75th anniversary, but as you can imagine, travel has been curtailed. And I know that most of this seems like ancient history, so let's bring it up to the present. 1 month ago, the International Criminal Court ruled that its chief prosecutor could open an investigation into allegations of war crimes in Afghanistan, including any that may have been committed by Americans. Now, the United States has not ratified the Rome Statute. Therefore, it does not recognize the International Criminal Court's jurisdiction over American citizens, and it also has no duty to assist in the court's investigations. If an American is indicted in this, that will be a first. So I'd like to, we'll leave some space for questions. I want to say thank you for tuning in to our first live stream program. For as long as we are all practicing physical distance, let us remember the importance of social connectedness. And the Jackson Center will strive to give you perspective, entertain you, help you learn, and keep you and your loved ones mentally strong. And as we dream about a world where the universal principles of equality, fairness, and justice exist, which I know is always, we will do our best to keep shining a light on these stories. And I look forward to meeting up with you all virtually again soon. Now, are there any questions? All right. Well, thank you all so much for being here today, and I hope you enjoy the rest of your day.